Hot off the presses, another research university has had a False Claims Act filed against them by current and former employees. In this case, it's Georgia Institute of Technology and also Georgia Tech Research. The whistleblowers in this False Claims Act alleged that Georgia Institute of Technology was not compliant with their DFARS 7012 contractual requirement and did not fully implement NIST SP 80171. So in this video, I'm going to give you my analysis and look into the actual allegations as it pertains to NIST 80171. And you certainly want to stick around to the end because I'm going to give you top 5 things that research universities can do to reduce the risk of having a False Claims Act complaint filed against them. So let's get into it. Now, before I get into my analysis, I do want to give the disclaimer that I am not an attorney. I am just giving you my analysis from a certified CMMC assessor's point of view. Therefore, my analysis is going to be specific to NIST SP 80171 and their interpretation of the controls. But none of this is to be construed as legal advice or official legal analysis. I first came across this story yesterday while perusing LinkedIn on a beautiful Saturday afternoon. I came across Stephanie Siegman's page. She is an attorney and she shared the complaint and essentially broke the story on LinkedIn that another research university has a False Claims Act against them. We all are familiar with the Penn State False Claims Act complaint, and that was back in August 2023. Now here we are again. To my knowledge, the Penn State complaint has not been adjudicated. Penn State, everyone involved, they are innocent until proven guilty. Also with this case, the Georgia Institute of Technology, everyone named in the complaint are innocent until proven guilty. It is a complaint filed by the whistleblowers. According to attorney Stephanie Siegman, this current false claims complaint against Georgia Institute of Technology was unsealed on February 23rd of this year. So now we public can view it and see what the plaintiffs / whistleblowers are alleging. I'll briefly show you just the title page of the complaint. Just wanted to highlight who the plaintiffs are, also known as the relators. So we have Christopher Craig and Kyle Koza. Christopher Craig is currently still employed at Georgia Institute of Technology and serves as director of cybersecurity. And Kyle Koza was a former employee of Georgia Institute of Technology and served as a information security engineer based on the complaint. And as we can see, the complaint is against Georgia Tech Research Corporation and Georgia Institute of Technology. The complaint refers to the defendants as GIT. So as we can see by the complaint, the plaintiffs are requesting a jury trial, and this False Claims Act case was brought again by the plaintiffs in the Northern District of Georgia, Atlanta division. So that's what's unique about the False Claims Act, also known as whistleblower cases, is the actual whistleblowers can bring the case on behalf of themselves. They don't have to wait for the Department of Justice to bring the case. Through the DOJ's Civil Cyber Fraud Initiative, they certainly are incentivizing whistleblowers to come forward with these False Claims Act cases. And unlike with Penn State, where the federal government decided not to intervene in the case, meaning they didn't want to join or attach themselves to the case, according to attorney Stephanie Siegman, the government has decided to intervene with this case. So in my layman's understanding, again, I'm not an attorney, but I interpret that as the Department of Justice will essentially attach themselves to this case and also present evidence on behalf of the federal government. So I think that's a really big deal. Another high profile False Claims Act case was brought by a whistleblower, Aerojet Rocketdyne, and in that case they ultimately settled $9 million, and the whistleblower gets a percentage of that settlement. In that case, the federal government did not intervene. The judge in this case has ordered the DOJ to file their own complaint within 120 days. So we'll see if the DOJ's complaint has more details and evidence that they present to GIT's alleged non-compliance with DFARS 7012. It is worth noting that GIT is a major player in research, especially for the Department of Defense. The complaint outlines that GIT has over a $1 billion research portfolio, hundreds of Department of Defense prime contracts, and also contracts as a subcontractor with Lockheed Martin. DoD research funding is a major part of their research program. A lot at stake, I would imagine, for GIT in this case. So it's sad to say I spent my Saturday night reading through the complaint. It was only 34 pages, but of legalese, that can take a while. It could be quite boring typically. However, I must say reading this complaint was quite juicy. There were some interesting details alleged in this complaint, made for interesting reading to say the least. If you're not a compliance geek like me and you have no desire to read the 34-page complaint, then you're in luck, because I'm going to summarize some of the key takeaways, and especially from a control standpoint, looking at the NIST 800-171 control. I'm going to do that analysis for you and let you know what's alleged in the complaint. Let's get into some of the specific examples that are alleged by the plaintiffs. First, looking at 3.12.4 is the requirement to have that documented system security plan, SSP. And the plaintiffs are pointing out that for Georgia Institute of Technology, they have several controls in their SSPs that are marked as not applicable without authorization from the Department of Defense. So that's one of the first things that jumped out to me wearing my assessor's hat was in one of the stories shared by Koza. According to him, one of the system administrators stated that lab had an exception to policy to install antivirus on specific servers. And I immediately thought the university does not have the authority to grant exceptions to NIST 800-171. Only the DoD CIO can grant any exceptions to 800-171 controls, and that exception would be granted on the conditions that GIT has found a substitute that is an equally effective measure. In this example, with antivirus installed on the servers, if the university has taken a risk-based approach and has requested that control be not applicable, which I highly doubt DoD would approve that. But from a risk-based approach that the university can do internally without even requesting the not applicable from DoD would be to determine, all right, we can't install antivirus on these servers. However, we're going to implement compensating controls, whether that's providing some type of logical separation or whatever the university determines is appropriate compensating controls to put into place that will reduce the risk to an acceptable level. In regards to the system security plan and any of the NIST SB 800-171 controls, the defense contractor does not have the authority to just mark controls as not applicable. Again, right now, all we know is what the plaintiffs are alleging. Let's take a look at DFARS 7012. Look at the actual contractual language that's in DFARS 7012. So now we're looking at DFARS 7012, the Department of Defense contractual clause that likely all defense contractors has this clause in their contract, and subcontractors likely have this in their teaming agreement. But DFARS 7012 is that contractual clause that imposes the requirement for defense contractors that's handling controlled unclassified information at CUI to implement NIST SP 800-171. So if we search for not applicable, we'll see in clause C where it says if the DoD CIO has previously adjudicated the contract's request indicating the requirement is not applicable, it must have an alternate or equally effective control in place, and a copy of approval shall be provided to the contracting officer when requesting under the contract. As an assessor, I want to see that copy of the approval from the DoD CIO. If a defense contractor has controls marked as not applicable in their SSP. Starting in clause B, it outlines that the contractor will submit requests to vary from NIST 800-171 in writing to their contracting officer for consideration by the DoD CIO. Contractor need not implement any security requirement adjudicated by an authorized representative of DoD CIO to be non-applicable, or to have an alternative but equally effective security measure that may be implemented in place. And since we're here, one more thing I'll highlight, because it is the crux of the complaint by the plaintiffs in this case, is the contractor shall implement NIST SP 800-171 as soon as practical, but no later than December 31, 2017. I see the plaintiffs are positioning their complaint based on that. DFARS 7012 clearly says defense contractors have to implement NIST 800-171 by December 31st, 2017. That's why I always tell our defense contractors, clients, is to make sure you understand your contractual clauses and especially read DFARS 7012, know exactly what's required of you as a defense contractor. Now, I will say we all know that with DFARS 7012 with NIST 80171, CMMC. There's a lot of confusion, a lot of fluidity around it, a lot of gray areas, even amongst assessors and C3POs, those that are in the DIB. There's a lot of varying interpretations of what the controls require. However, I wanted to point this one out related to not applicable, because that one, I would say, is pretty clear. But another thing that this complaint highlights is going back to the deadline for defense contractors implementing this 80171 by December 31st, 2017, is the DoD is expecting full compliance and expected to score that 110. That's a pretty high bar. Ultimately, implementing 80171, whether it's a small environment or a large environment like GIT, is very challenging. It's not easy. It's no small undertaking. And I would say it's even more challenging in a research university environment where you have so many different stakeholders, you have so many varying labs, and lots of complexity and room for misinterpretation. All right, next up we have 3.1.1. So Craig and Cozy, remember these are the complainants, and recall that Craig still works for GIT as Director of Cybersecurity. They observe multiple systems with inbound connections allowed from external corporations not listed in the SSP. So 3.1.1 requires controlling access to those in-scope systems. Going back to the SSP, they're saying it's not accurate, it's not complete, it's a misrepresentation of what's actually going on in the labs at GIT. Again, these are their allegations, and we'll see what else comes out from the DOJ complaint. Going through them one by one. The next one they listed was 3.1.2, saying more than 100 systems located over half dozen networks are listed on SSP, but connection and relationship between those systems are not documented. Generally speaking, as a defense contractor, you're processing, storing, and transmitting, controlling, and classifying information. Part of properly implementing this 80171 is you have to document the connections, the in-scope systems, how you are satisfying the 110 controls outlined in 80171. Craig and Koza, they're pointing to that those system security plans for the labs at GIT are incomplete. They are not an accurate representation of the full scope of the lab systems and connections. That's why when Aspire Cyber is consulting for defense contractors, helping them comply with 80171, we spend a lot of time in the scoping phase, making sure we've accurately scoped their environment, know exactly what systems, processes, facilities, technology, process, store, transmit that CUI. Because if a defense contractor accidentally or intentionally leaves systems out of scope that should be in scope, that can potentially open them up to a False Claims Act. No one wants that. Really need to make sure that scoping is accurate. This is just some lessons that defense contractors can learn from this complaint. But there's more. We have more specific examples that Craig and Koza point out in their complaint. Next, take a look at 3.1.21. So this one is relating to controlling external devices, so like thumb drives, external drives. So this is a control, according to Craig and Koza, that is marked in the SSP for the GIT labs as not applicable. And they're stating that, and then in SSP, they say that it states that external drives are not used in the lab environments, therefore the control is not applicable. But Craig and Coles are saying, hey, the intent of that control is to limit or control the behavior and have actual limits or controls in place, whether technical and or administrative controls. You can't just say we don't allow USB drives and leave it at that. That's not going to be sufficient for a CMMC assessor to mark that control as met. Remember, and I'm sure you all know very well, that each control has corresponding assessment objectives, and those are the objectives that the assessor are going to look at. In the complaint, they're saying that this is another example of a control marked in the GIT SSP as not applicable, that has not been approved by the DoD-CIO. As a defense contractor, it's critical to remember that every time you submit an invoice to the Department of Defense for payment, you are attesting that you are complying with all your contractual requirements, including DFARS 7012, which requires you to implement NIST 80171, all 110 controls. So what's being alleged in this complaint, all these specific examples, is the plaintiff's attempts to prove their case that GIT labs are not compliant with 800-171, and they're going even further to say they were knowingly non-compliant but still submitted invoice for payment to the DoD, resulting in false claims. Next one, 3.1.22, the control CUI posted a process on publicly accessible information systems. This is another one saying that's marked as not applicable without DoD adjudication. Remember that adjudication, approval by the DoD CIO. I haven't heard of or came across any defense contractor that has actually received this adjudication from DoD, but in the rare cases they do provide that adjudication, DoD would provide a copy to that defense contractor that they'd be able to present, that they would include in their SSP, or that they would have on hand to present to a CMMC assessor to prove they have that adjudication. We know with 3.1.22 is a matter of having a process in place to ensure that no CUI or even FCI is being posted on publicly accessible websites or other types of sites, SharePoints, anywhere where individuals who do not have authorized access to that information can view it. The GRC, the Governance Risk Compliance, these are essentially the internal auditors at GIT, responsible for auditing and helping the labs comply with this 800-171, and states that the two-factor solutions are LastPass and dichotic secret server. The whistleblowers in this case, Craig and Koza, are saying that two-factor authentication Duo is the only capable solution of protecting local access for privileged accounts. But the SSP for the GIT labs outline that they're using LastPass and dichotic secret server for two-factor authentication, which, if that is the case, would not be compliant solutions and control would not be met. The next specific example of non-compliance that the whistleblowers point out is 3.13.1, controlling those inbound and outbound connections to the in-scope systems. So the whistleblowers are saying that the time the SSP and a report on compliance were signed for the Astro Lavos labs, the majority of the systems listed on the inventory were on a network that did not have a firewall. 3.13.1 does require controlling inbound and outbound access to in-scope systems. And according to the whistleblowers, that was not happening. There were systems in the Astro Lavos lab that was not controlling those inbound and outbound network connections with the firewall. Next one, 3.14.2, in the same lab, saying no endpoint protection agents were configured, and the firewall did not have anti-malware protection turned on. And apparently I listed 3.5.3 twice. It was just that juicy, had to list it multiple times, but clearly typo, the same one about the two-factor authentication. Those are the specific examples of non-compliance that the whistleblowers point to in their complaint. In addition to those, there are a lot more details related to specific stories, and I'll just kind of summarize them for you. So apparently Koza did document his concerns related to non-compliance in the GIT labs via Georgia Tech's ethical hotline complaint system. Can't think of the exact name right now, but essentially he did document his concerns and alleged observations of unethical behavior. And apparently him and Craig had some exchanges that they viewed as unethical with the CISO. A lot of more details. I'm not going to go into this for video. You'll have to actually read the complaint to get into those. But long story short, there was apparently a history of the whistleblowers complaining and reporting non-compliance with the DFARS 7012 clause. So it'll be interesting to see what all comes out, especially in the DOJ's complaint, see what evidence they uncovered during their investigation. I'm sure there's much more to come. But as promised, I do want to close this video out with kind of giving you some of my recommendations or what I view as lessons learned from just kind of recurring themes that we're seeing from the Aerojet Rocketdyne case, the Penn State whistleblowers case, and now this one. These are just some things I would recommend to defense contractors of steps that they can take to reduce the risk of False Claim Act complaints. First thing I would say is certainly want to make sure that all stakeholders who are going to be processing, storing, and transmitting, controlling, and classifying information in the performance of the Department of Defense contract, make sure they understand in this SBA 171, what's required of them, what role they play, at a minimum, understanding the DFARS 7012 clause and what's required. I know that 171 is a technical publication. So those that don't have the technical expertise, they may not understand what the actual controls are requiring of them. Therefore, they're certainly going to have to either hire someone internally to make sure that their interpretation of implemented controls is correct, or hire certified consultants, whether that's C3POs, RPOs, certified assessors like myself, to make sure that you're on the right track as a defense contractor, that you're properly interpreting the requirements and implementing the controls, because I'm sure your company or your university does not want to be in the headlines for a False Claims Act complaint brought by whistleblowers. So that brings the next one as far as authority aligned. And in this GIT complaint, that was one of the things that was outlined, is that there was just gross misinterpretation by the system administrators in the various labs for the NIST 171 requirements. So I don't think it's going to be a valid legal argument that's going to carry much weight with the judge if you as a defense contractor says, I didn't know, I didn't understand the requirements. And I know it is a dilemma, even amongst the CMMC experts. There is some interpretations that are some gray areas where we're still relying on the Department of Defense to provide greater insight and more clarity around what is CUI, more clarity around the requirements. So hopefully that's forthcoming sooner than later, but it's better to play it safe than sorry when it comes to DFARS 7012 and implementing 171. Make sure that you're properly implementing this 171 requirements. Number 2 on the top 5 list, I would say, is making sure that having the proper authority aligned with accountability. So going back to lessons learned from this GIT whistleblowers case, is they highlighted that Craig, Director of Cybersecurity at GIT, the GRC teams, those internal assessors tasked with overseeing the compliance and helping the labs get compliant, really didn't have the proper authority. Even though they reported to Craig, who reported to the CISO, according to the whistleblowers, they just didn't have the proper authority. They were accountable, but didn't have the authority that was commensurate with their accountability. And I do see that a lot just in general with organizations where an IT person may be tasked with handling the CMMC project, but CMMC 171 compliance with DFARS 712. This is not an IT problem. It's an organizational responsibility, and it's going to require the entire organization to satisfy those requirements. Can't just put it on IT and say, handle it for us. Not going to work that way. Next one needs to certainly have those clear separations of duties, as was pointed out in this complaint. There wasn't really clear separation of duty between the system administrator, CISO, and the research governance department. According to the whistleblowers, was not sufficient. It's required by 171 to have separation of duties. The personnel that's implementing the controls should not be the same ones assessing the compliance of those controls. You need to have those separation of duties. That's really important. Whether you're bringing in an external consultant to perform the assessment, which a lot of organizations prefer doing that. And then number 4, I want to have protection for those internal audit team members, making sure that they are protected against reprisal for pointing out non-compliance. They're not going to have to experience any retribution or negative impact on their career because they're reporting non-compliance. So they're going to have to make sure that they are protected. And again, kind of goes back to separation of duties, having the proper authority aligned to the accountability. Because in the complaint, it points out that Koza was forced to resign. Now, what the details behind that, we don't know yet, but essentially he's alleging that his career was negatively impacted and he received several indirect or suggestions as a result of pointing out that non-compliance to the CISO. And I recall in the complaint where Koza pointed out, as a result of the university not taking action based on the times that he documented via email and their system for reporting unethical conduct, that he felt over that period of years, the university did not take the appropriate action. Certainly, as an organization, you want to avoid that. Want to make sure that your employees feel empowered to report what they deem as non-compliance and that is properly investigated, because otherwise, if it's ignored or if the proper actions are not taken, could increase the risk of your organization being hit with a False Claims Act complaint. And last but not least, I'll say to round out my top 5 recommendations, clear escalation channels. The stakeholders, employees feeling empowered to report anything that they deem as non-compliance to the appropriate authorities, and the proper investigations are taking place, knowing exactly how to report non-compliance without fear of reprisal or reprimand. So those are really just my personal professional opinion and just really some lessons learned from this complaint and then other high-profile False Claims Act complaints that relate to DFARS 7012 and this 171. It'll be interesting to see how this False Claims Act case plays out and see if the whistleblowers ultimately prevail. If I was a betting man, which I'm not, I would bet that GIT does settle this case, especially considering the DOJ has intervened. Hope you got some value from my analysis from a certified CMMC perspective. I'm curious to hear your thoughts. You think it has some substance? What are you predicting is going to be the outcome?